The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talkboard TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Expert show. I am your host, Steve-O. We have a great show today, and the phone lines are already ringing like crazy. This is the Ask the Expert show. We are talking about community association law today. We're in the fine city of Orlando. And if you'd like to call into the show, well, first of all, you can chat with us. If you're watching us right now, you can chat and we will take your questions. We've also got many questions that you have texted me. We're going to try to get on as many of those as we can today. And let me introduce you to our expert, the guy I love doing the show with, attorney Alan Swartzide. Good afternoon, Alan.
Steve, how's it going?
I'm doing good. How's the weather there in Orlando?
You know what? I was just driving in 5 minutes ago, and for the first time in a long time, it's not too cold, it's not too hot, and it's not raining. I feel like I must not be in Florida anymore.
Hey,
I got no complaints.
You better knock on wood, bro.
Done.
So tell everybody about Kay Bender-Rimbaum, one of the greatest HOA Condo Community Association law firms in the state of Florida.
Well, I'll take that endorsement any day. Thanks, Steve. Our firm's been around since the 90s. All we do is represent community associations, and that's been the case, I think, since day one. We've got 21 attorneys, and I can't announce who yet, but we've got another person starting in my office, which is the one that's based in Orlando that I manage, on Monday. So we're very excited to have him joining us. That'll be number 22 with the firm. We've got offices in Orlando, Tampa, Palm Beach Gardens, and our primary office is in Pompano. We've also got Miami by appointment. But bottom line, if your community association needs literally anything, including construction, which most law firms have to farm out, we do have a literal expert, in my opinion, and in the Florida Bar's opinion, because he's board certified in construction law. One of our attorneys is fantastic, and I've been working with him a lot more lately, especially with some of the changes that have come across this year in reducing the amount of time your community might have to try and get issues addressed before you got to file a lawsuit against the developer if there are any construction defects in your community. So that's us in maybe the elevator pitch version is what I like to say. I'd rather get to the content, but I appreciate the opportunity to explain who Kay Bender-Rimbaum is, because honestly, it's just a great firm. I wouldn't be back with these guys after a couple of years away if that wasn't the case.
You know, I love what your firm does. Man, you guys are so busy, but you take the time out, like the show like this, and we have another show we do in Tampa and another one in South Florida. You take the time to educate people out there for free, and there's not a lot of law firms that do that. Plus, you've got so many classes and seminars and courses free that you offer.
Well, Steve, this is event number 8 of the last 2 weeks for me. And I like to be able to say that finally, as much as I enjoy it, my hell 2 weeks is finally over. I get to do just a very relaxing one with you, although I enjoyed most of them. I got to do 2 in person, which I haven't done in a while. But I really do think, and so does the other attorneys at our firm, we really find the education piece important because, frankly, without that, our job is actually harder. This education is not entirely selfless. It makes our job easier when the people that come to us wanting advice have already got at least the basics under their belt. So when I have, I put on a seminar and someone reaches out to me and says, hey, we heard what you have to say. We like what you have to say. We love the fact that you offer a 24-hour turnaround time because our attorney is taking a month to get back to us to even acknowledge that we asked a question. It makes it easier for me to be able to give them guidance if they've got at least the basics. And I can use a little bit of that legal mumbo jumbo that I try really hard to avoid.
Alan, we're starting to get calls from board members. And they're wondering, of course, I guess they have another law firm because they're asking if they could change law firms because they enjoy you and your show and the way Robert Kay does the show. And can that be done? Can they get like second opinions or possibly leave the firm they're with and come with you?
Absolutely. I mean, I'm not aware of anything that would tie an association to a particular firm. Even if it's an exclusive agreement that can be broken, it's not a permanent, indentured servitude by any means if you're under contract with a law firm. But you mentioned second opinions. That's where we start with a lot of the clients, especially in the Orlando area, is we want you to work on one project. And then they see how we operate, how responsive we are, how knowledgeable I am, the rest of the firm is, and frankly, having the back up of 20 other attorneys, soon to be 21, helps a lot for me and the rest of our clients. But the short answer is, yeah, absolutely. There's nothing that says you can't have two attorneys. Some people have an attorney that just does collection for them and someone else does everything else. I like to keep it all within one firm, but there's nothing that says you can't have two or three firms that you're working with at a time. So the shorter answer is yes, absolutely. If anyone is interested in a shift of counsel or even getting a second opinion on one issue, I welcome everyone to reach out to me either on LinkedIn or preferably via email at as@kbrlegal.com. LinkedIn is another place that I try every day to either post that we've got seminars coming up, which I consider an hour's worth of helpful material, or just some helpful tip that's like 2 sentences long. I post something every day throughout the work week, even on holidays if we're not working, just not on the weekends. I try and keep that to the family.
You're in several markets. You're in Orlando, where you are, where you're in Tampa, Palm Beach, South Florida. Is it just one website for all the cities?
Yes. So, if you want to go look up more information about individual attorneys within the firm, that is on our website. But, the only thing different between the Tampa office, the Orlando office, the Pompano office, and Palm Beach Gardens is the address. And with Zoom being such a prevalent concept, and frankly, phone calls having been a prevalent concept for 100+ years, realistically, the location of your law firm doesn't matter all that much. Even if you get into litigation and the attorney has to travel once in a while, I haven't seen it as an issue, especially since COVID, where, I've got clients in Miami, I've got clients in St. Augustine, and I've got clients in Orlando, and all of them have no problem working with me or anyone else at the firm. Now, if you prefer, let's say you're in South Florida, you prefer to work with a South Florida firm, that's still us. But if you want to be connected with one of our folks in South Florida, that's something I'm absolutely happy to do. Because frankly, we have some fantastic attorneys down there.
Hey, let's go. Our phones are buzzing right now. Let's go to Joe in Palm Beach.
See, Palm Beach. There you go.
Hi, Joe.
Hi. Just a discreet question. If Condo Association quarterlies are due on the first of the month, and it says that if they're received after the 30th day of the month, additional interest will start running at pick a number, 10%, whatever the rate is.
Okay.
Would the interest then go back to start from the due date of the first of the month?
Generally
In other words,
speaking,
there's an interest-free period of 30 days, but
right. I understand what you mean.
yeah,
So
okay.
you've got that 30-day time frame in between, and the question is, does it start on day 31 or does it start on day 1? And frankly, the answer that you'll get from every attorney about almost every question, except for our firm, is it depends. Because really what it depends on is, what does your declaration say about how that interest accrues? So what you would need to do is look at that provision that you're referring to, Joe, and see, and frankly, you probably want your attorney to do this, but make the determination. Does the declaration say that it accrues beginning on the 31st day, or does it say that it accrues on unpaid assessments beginning on day 31, that it might be retroactive to day 1? So it's really just a matter of, what does the declaration say? If it's not clear, I would be surprised to see a judge say that it's not retroactive to the day that the assessment was actually due, because that's generally what this Florida statutes provide. But again, you're going to want to look at your specific provision of your declaration.
Yeah. So what you just said is helpful too. That the statute does say that the interest starts from the due date, which would be the first. Would it not?
Generally speaking, yes.
The date
Your declaration will control over the statute with respect to the date that it actually starts. So if your declaration is silent on when it starts, then it generally would start on the day after the assessment was due, or the day of the assessment. If your declaration has a more clear statement on that particular item, then you go with what's in your declaration or your bylaws.
Okay. Very good. Thanks very much. Thank you.
All right. Thank
you,
Joe.
Yep. Very good.
Hey, we have a line open now at 561-623-9429. We have got so many questions. You know, education is so important, Alan, and I know you agree with that.
I do.
From what I understand, there's a bill being worked on now for the certification.
There is. So what it would require, and myself and Jeff Rembaum of our firm just did a class on this, or at least a webinar on it about a week and a half ago. And essentially what this would require is that, and it's something both of us have really been pushing for because education is important. A director currently can either sign a piece of paper that says, I've read the governing documents and I'll do my best to uphold what's in them, or they can do the right thing and actually get educated, take a board certification class. This would require not only both of those two things, because let's be realistic, the person that's signing that certificate either hasn't read the governing documents or has no idea what they say, because most attorneys can't interpret what they say. So what you're looking at is you're required to do both under this new bill. In addition to something that I think is also important, yes, you are required within 90 days under this bill, after you become a director of an association, you need to take that class and sign the certificate. But there's also a continuing education component that currently doesn't exist at all under Florida law, which I think is important. That's part of why we teach these, I'll call them elective classes, and not just the board certification classes that are actually required. Because I think you should know more than the very basics that someone can teach you in a 2.5-hour class.
I agree. Hey, Juan, let's put up Karen's note for Alan to read. What is the difference between prospect, declaration, and rules and regulations? Which changes need to be voted on for condo owners?
So the prospectus is basically the document that the developer creates to say, here's the community that we think we're going to put together. It's basically the way that the developer gets the community approved for construction. That's a very, very oversimplified way of putting it, but that's the very basics. By directive, I candidly am not 100% certain what you mean. You might mean the declaration, which is the declaration of condominium or your declaration of covenants and restrictions. That's kind of like I would call it your mini constitution for your small community. And it may be a large community, but that is your constitution for the community itself. And then when you talk about rules and regulations, those are generally going to be things that the board creates without the members voting on it. So when you ask, do the members get to vote? If you're changing the declaration, the prospectus really is difficult to change if you're not the developer, because they're the ones that create that and would amend it before the community is developed. Once the declaration is in place and the members are in place and have control over the community, they've done the transition of control, or after the community's been created and the developer still has control, your declaration is usually going to be something that if the developer's still in control, developer gets to change it almost at will. If the members are in control, meaning people have actually bought units in the condo or bought lots in the HOA, the members will get to control most of the time the changes to the declaration and the bylaws. What you'll want to do is look at the amendment provision in those documents, because I have seen sometimes where the board of directors does get to make those changes unilaterally without the members' input. And keep in mind, when I say without the members' input, I don't mean without a board meeting. What I mean is that the board of directors generally gets to do that at a board meeting without a member vote. Same with rules and regulations. And keep in mind that each one of these documents is going to be a different level of credence. And the difference between them is that a judge is basically going to presume that if the members get to vote on something and it's not against Florida law, meaning there's no case law, there's no Florida statute, there's no federal law that prohibits it, it's probably valid unless it's arbitrarily enforced. Whereas your rules and regulations, there's a reasonableness component and it needs to be supported by your declaration. So these are three very different documents. I hope that 5-minute outline was helpful.
That was great. I got the greatest text that came in. It's from a gentleman who just finished law school, is getting ready to go out there.
Okay.
He is going into real estate law, but he listens to your show every month and said he's learned more from your show than he did in law school.
Well, I'll be candid. In my experience in law school, you learn how to think like a lawyer in law school, at least to some extent. You don't really learn the law in most respects. But I will say in the condo class that I took, I learned probably more practical application of how to really practice law than most other classes. So I appreciate the comment. Feel free to reach out to me if you need any help. But what's funny is I initially intended to go into real estate, came out of law school in 2008 during the foreclosure crisis, and guess where I ended up instead? Mortgage foreclosure land for 2 years. And then in 2010, I learned, maybe I want to really practice law. So that was the first round of me coming to work with K. Bender Rembaum, was 2010 to 14. And then I made what I won't call a mistake, but I'll say it was something that I decided to do, was walk away and try out some other firms, and realized there's just nobody better.
Yeah, you know what? We get so many calls from law firms that listen to your shows, our South Florida show, our Orlando show, today, our Tampa show. And I got to tell you, we've been doing this for 9 years now. Do you know we've never had a derogatory comment like our firm's bigger, our firm's better? They always are so complimentary. And I don't get that with my other areas of law, believe me. So you've got such a great reputation when it comes to condo and community association law.
Well, thanks, Steve. I also think that our industry, the community association industry, is a lot more collegial than a lot of other areas of law. It's not, you're not necessarily going head to head every day. It's the occasional an owner has a problem or an association has a problem that you really need to butt heads. Most of the time, community associations try to work things out, and the ones that don't are the ones that end up on the news.
Let's go. I don't know if this next one is a phone or if it's a text. Terry? Is that a phone? Okay. Now I got it now. This is a text.
Okay.
Terry. We won't mention anybody's last name. You don't have to give us last names at all. Our board requires owners to certify in writing that we read our government docs to run for the board. I agree that should be done. I disagree that it complies with the letter of 720. Any feedback is appreciated.
If you are requiring potential directors as nominees to do anything other than put their names in a hat and make sure their assessments are up to date, chances are that is not authorized under 720. It may be in your governing documents, and that's something that you'll want to talk to your attorney about, whether the fact that it's in your declarations or your rules and regulations is sufficient to make it a requirement that doesn't violate Florida law. My opinion is it's not a bad idea, but that doesn't make it legal. And my concern is that by saying, again, when you certify that you read the governing documents, you can't certify that you understood anything that's in there. And that's the problem I have with this type of requirement is, listen, you want to require that people take a board certification course in advance because that is valid for up to a year before you actually get elected? Absolutely. I don't have a problem with that. The problem I do have with it is that it's not something that you can require, because Florida law is pretty clear, and 720 and 718 are each pretty clear that in order to be a nominee, you just have to be basically sometimes an owner, sometimes not within the community. But there are 4 or 5 disqualifying factors. Everyone else is eligible to be a nominee. So to add qualifications to that, I just don't know that it would be even remotely supported by Florida law. I'd like to see everyone take that class in advance to determine whether or not this is really something they want to do. But to sign a piece of paper that says I've read the documents, it's, from my perspective, it's meaningless to even require it. So why risk that you're butting heads with Florida law?
We've got a lot of comeback notes here from Terry. I think 720 says it needs to be done within 90 days after.
Right, and that is correct. So within 90 days after, but to require it in advance to be even considered as a nominee is what I have a problem with.
Then she says nothing in their government docs, board certified course should be mandatory.
I wish it was, and that's what we talked about, Steve, a couple minutes ago, that there's a bill out there to make it mandatory, but there's nothing out there that would make it mandatory in order to be considered for the board. It's all, you have to do it after you are elected within those 90 days. So there's, I'll just be straight up. There's nothing that can require, in my opinion, someone to take a board certification class or certify that they've read the governing documents in advance of the election to be considered as a nominee.
Well, Terry said she agrees with her cousin Alan. She's actually watching on our YouTube station right now.
All right.
That's
well, thank you, Terry.
This is great, because how many times can you get advice from an attorney for free? And that's what we're doing here. Thank you to Kate Bender Rimbaum. It's we need to go take a break.
All right.
Get notify Juan, and when we come back, we have more with Kate Bender Rimbaum, attorney Alan Swartzy.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And yes, we're back. We're going to go over the classes and seminars you have coming up. And I want to just share this with everybody. We do literally about 50 shows a week, and they're all over the country. I have to tell you, the K. Bender Rimbaum shows, the ones we do in South Florida, the ones we do here in Orlando, the one we do in Tampa, is our number one, I guess, participated show between people calling in, texting in, and the chat line. This is our number one show in the country. And I'm going to tell you, when you have that, you know that people are enjoying the information, and we're enjoying you sitting and listening to the information. So, Alan, I just want to thank Kate Bender Rimbaum. You are without our number one show in the country.
Well, I'm going to give it up to Robert K. and claim that that's all him.
Yes, Robert. So you got a lot of stuff coming up.
Yeah, I know you're surprised by that, right, Steve?
Yeah, right. Because you never do anything.
Yeah, we're always just sitting around. You want the rundown real quick, Steve?
Please.
All right, let's do it. So we've got a class about updating your governing documents and why that's important coming up on that was today, actually. So I guess that's not coming up. But that will be on our website under the resources tab, probably within the next few days. The next one we've got coming up is actually, I lied, it's on the 30th. And that's the HOA Bill of Rights. That's Emily Gannon of our Pompano office. She's going to be doing that with Associate Florida live via Zoom at 11:30 on the 30th. We've got Striking the Right Balance, Fair and Consistent HOA Enforcement, which is a semi-new class. Emily Gannon is going to be doing that. It's hosted by Affinity Management on the 31st at 11 a.m. I'm going to be doing the legal update for this year, and that is not the new bills, although I'll be talking about them, but that's the changes that were made for 2024. That's on the 31st, again, via Zoom at 2 p.m., so we're not interacting there. You can attend both if you really have nothing else going on that day. We also have February 1st, Safety and Serves, Reserves to the Rescue. This is, again, live via Zoom, Jeff Rembaum, noon on the 1st. And then the next one we have scheduled, although my guess is I'll be shoving another one in there, is Association Board Member Certification for Condos specifically on the 15th of February at 2 p.m. Again, that's a Zoom. I've got Covenant Enforcement for Community Associations on February 20th. At 2 p.m. via Zoom. And I'm also going to be, if you're in Orlando, teaching that covenant enforcement class live at the CAI trade show on the 23rd in Orlando. I believe that's at 10 a.m. But you'll if you're signing up for the CAI trade show, just come find me. You'll see me probably wearing either this shirt, or I know the theme is magic this year, so I might break out some Harry Potter gear instead.
Hey, and the food is free. You will have to pay for restrooms. Kate Bender makes you pay for that. No, I'm just kidding you. You know, I guess sometimes we don't make everybody know for sure. We are condo and HOA, not just condo. And we have, our list is so long of people texting us in. I just found another list thanks to one. If this is limited to HOA, please disregard. No, we handle for HOA also. My question is related to Condo Association and the fining process. 718 states, fine cannot be a lien. How can the fine levied be collected?
So my first answer is stop wasting your time fining people. Do real enforcement. Force them to actually cure the violation and stop the bad behavior. But if you choose to fine anyway, the only way that it can be collected in a condo, And 718 is the condo statute, the Condo Act, just for anyone that doesn't know what that meant. The only way to collect it is via a lawsuit demanding payment of the fines. And guess how much a judge is going to love you for filing that lawsuit? Normally what I see, and the reason that I say I don't really like fines, is because no one actually files that lawsuit. You have that fine sit around for 5 years until it becomes unenforceable, or you throw it on an estoppel certificate when someone goes to sell or refinance their unit. And then guess what the first thing you're going to waive is when they ask to reduce the total balance so that they can pay off the estoppel. Those fines are going to disappear. You're killing the board's credibility by just having those amounts on the account that you're never going to collect. So go after the real enforcement. One of the first things that I do with every community that I work with through our Orlando office is recommend that they create policies that I can prepare for them for covenant enforcement, meaning you're sending a couple letters and then sending it over to us to seek an injunction if they don't cure the violation, and have a judge tell them that they need to fix the problem. Collection, meaning unpaid assessments, which we talked about a little while ago, and then your records inspections and member participation in meetings that we also talked about. Those 4 policies are something I think every community association in Florida should have. But that's the long version of the answer. The short answer is you file a lawsuit seeking damages.
Okay. This is from the chat line. We're starting a capital contribution. Board wants to control. I want owners to control. I'm going to tell you something. We're getting a lot of letters. People are concerned about the board with all this new money the board's going to be handling. People are a little concerned about that, Alan.
Well, I mean, there are streamlined processes in place where the board really can't use a lot of these reserves, which I presume is what you're referring to, for any purpose other than reserve assets. So, excuse me, yes, of course, we've seen problems that have occurred, but the bottom line is that's such a small percentage of communities that, yeah, there may be a higher incentive if there's more money lying around to be played with. I just don't see that happening. Steve, can you put that back up, the question, so that I can answer? Frankly, I went and got off on a tangent and I forgot what the original question was.
Okay, there we go.
Contributions. So the bottom line is, yes, the board can control the funds once they're in, but whether you are requiring a capital contribution, if you don't already have that in your declaration, it would require an amendment to your declaration. So the members get to decide whether to have it or not. The board can decide to propose a specific amount. My suggestion is, in order to keep that kind of fluid so that there is the ability, without amending the documents, to actually change the dollar figure, you kind of leave that dollar figure vague and you put in there that it's, in an amount to be determined by the board from time to time. When you're talking about how to control the funds, which I presume to be the issue that we're talking about, in reality, the capital contribution would generally be something that you have a specific purpose stated in your declaration that the funds need to go towards X. Now, if your declaration is vague and it just says you collect a capital contribution, you use it for operating expenses, yeah, I can see the concern. But you can have something in your declaration that specifies what that money needs to be used for. And if the board uses the money for something else, or I think the concern is they abscond with it, they basically skim that money off the top and walk away with it, then that's a crime in and of itself, and you call the police. And frankly, like I said, yes, there are issues like what we've heard about in the hammocks down in Miami area. That happens. But again, it's less than 1% of all community associations in Florida. So to sit there and legislate this to death, or, have to have an amendment and spend $1,000, $2,000 to amend your governing documents every time you want to change that, I don't necessarily agree with it. If you're concerned whether your board is going to properly address the funds, maybe you should have other people on the board if you have that genuine fear.
I'm going to go to our text. This is from Guy in Orlando. He said, my wife and her card buddies don't miss one of your shows. That's a nice compliment. So I've seen some pretty major card rooms around the country.
Well,
But
and they can definitely listen to a lot of other things. There's plenty of podcasts out there. We appreciate that.
we do. What should a buyer do to make sure the seller doesn't owe any assessments?
I mentioned estoppel certificates earlier. That's literally the answer to your question. Just make sure that at the closing, or frankly, before the closing, you request an estoppel certificate. And thank you for asking that question, because it allows me to jump on a soapbox for a minute here.
Go for it.
There is a bill being pushed through the legislature right now where community associations would no longer be able to charge for producing an estoppel certificate. This is a horrible bill, in my opinion. And the reason for that is that right now, that expense is being paid for the expertise, the knowledge, and frankly, the potential liability of the person and the company that's preparing that estoppel certificate. The reason that that's being passed along currently to the person that is selling their unit or selling their lot, or the buyer, depending on how they deal with the transaction, is because those are the people involved in the transaction. Now, it may be a refinance that you're asking for this for. Regardless, right now, that cost gets passed along to the people that are involved in this particular transaction. What's being proposed is that you can't charge for it, but let's be realistic. Your attorneys, your management firms are still going to charge the association for that work.
Right.
What that means is every member of the community now has to pay for something that's only affiliated with one lot. And we have clients, I know Jeff Rembaum has mentioned, he's got one client in the Palm Beach County area that has so many sales turning over within the community that this would increase their budget by $70,000 for next year. That gets spread among the members instead of it being paid by the parties that should be paying for it. So
Right.
I urge everyone to reach out to their legislators and let them know this is a terrible idea. Please, not only don't support this bill, but push back against it. Because all it's going to do is hurt not only the community association industry, but the individuals who've already had their insurance costs mounting are now required to save up mandatory reserves, have all those reserve studies done, pay tens of thousands of dollars. And now you're telling them that at least in this one community, they should up their budget by yet another 70 grand for no reason. So now I'm stepping off that soapbox. Thank you, Steve.
People want to know. People want to know, does their voice really matter?
When you reach out to your legislator, they should be reading every one of those emails. Now, here's the problem. When you reach out to your legislator, if you're the only one that does it, maybe your voice doesn't matter. But when they get 50 emails and another 50 letters and another 20 calls from their constituents, these people should be taking that seriously and saying, oh, maybe this is a problem that I need to help with. Because let's be realistic. Your legislators are looking to get voted in again next time that they are up for re-election. So if they ignore their constituents, guess where that vote's going? To whoever else is on the ballot. So let your voice be heard. If you don't want to be paying for other people's charges, let your voice be heard, please.
Somebody just wrote in, thank you for mentioning hammocks, up to $4 million in theft.
And you know what? I'm not going to lie and say that that stuff doesn't happen. All I'm going to say is that it's so rare, or maybe it's just so rare that it's caught. But the bottom line is, if people are paying attention to what's going on with an association's finances, there's no way it should get to that point. The problem is that there are so many communities that people are just apathetic and don't care and let the board do whatever they want. And sometimes that's a good thing because the board's doing a good job. Sometimes, very rarely in my experience, it results in something like the hammocks.
We had Randy in Sanford. He said, is there anything special we have to do when we put up a no trespassing sign? Are we liable by doing that? And what is considered trespassing?
Trespassing is when you call the police and the police say it's trespassing, in my opinion.
Oh, okay.
That's the bottom line is someone shouldn't be on association property. You call the police. You don't get actively involved in that. Don't put yourself at risk. Don't put your manager at risk. Don't put your security at risk. I mean, your security, that's part of their job, but they should also be calling police if it gets to that point. Putting up no trespassing signs in a condo is questionable because that could be considered a material alteration to your common areas, meaning that it might require a member vote. In an HOA, unless your declaration says something that most don't, you can probably do it without a problem. And in a condo, you might be able to do it because it's for the protection of the community. Whether that creates liability for the association will depend on whether you had a reason to know that people were trespassing and causing problems. That's more of a premises liability issue or a negligence issue than anything else. It's, did you know that there was a problem that people are causing and that's why you put up the sign? Or are you just tired of people coming onto your property that aren't allowed to be there? Frankly, that's one that I can't give you a concrete answer as to what the right answer is without having the exact situation in front of me. And frankly, it's one of those you really should be reaching out to your counsel before you take any action on or choose not to take action.
Got so many questions here. I got to get this one in too. This is from Stephen in Orlando. He says, I know it's your fault the insurance is going up. Do you believe that? He didn't say that. No, he didn't say that. He said, we cannot afford our insurance going up. Is there a way a condo does not have to have insurance?
Statutory, unfortunately, the answer is really no. I don't think there is a way that you can have no insurance whatsoever. At a minimum, you might decide not to have directors and officers liability insurance, but that would be a great way to guarantee that no one's willing to serve on the board because they're not protected in any way by an insurance policy. I mean, you are obligated to maintain insurance sufficient to cover whatever damage might occur to the community. There are statutes in place that protect the association. And yes, the insurance costs are astronomical. Citizens actually has another bill to increase in the next few years what they will be charging and try and impede people from using Citizens without exhausting all other options, essentially. But the bottom line is I can't think of any way you could just say, well, we're not going to insure anything.
Understood. This next question is from Robin in Orlando.
Okay.
And we get a lot of questions like this. What can be done about a board that held numerous meetings and did not allow owners to attend? They met weekly for more than 10 weeks. Owners were told we could not attend.
So there's only two reasons why a board is allowed to hold what's called a closed meeting, which is where the members can't attend. And it sounds like that's what they're doing. One is if it's a discussion with counsel regarding potential or ongoing litigation. So if you've got either a lawsuit that the board is contemplating filing or that's going on right now, that might be one reason. If there's a trial coming up, there might be reasons to meet multiple times over the course of a couple weeks. The other one is to discuss personnel issues, meaning actual employees of the association, not employees of your management company. If it's neither one of those, then if the board's holding meetings and not giving, the opportunity of the members to participate and at a minimum attend those meetings, that's problematic. Now, the question was, what can we do about that? If this is actually wrongful conduct by the board, what you might do is send them a letter saying, we know what you're doing. And guess what? Either we're going to pursue arbitration with DBPR or mediation. If you're a condo, it would be you get to choose one or the other. If it is an HOA, you get to do just the mediation. And the alternative you might consider is a recall if the board refuses to do what they're legally obligated to do. And that's basically where, regardless of whether there's wrongdoing or not, if a majority of the members of your community vote in writing or end up at a meeting where 20% of your members voted in writing to ask for that meeting and decide that they want these people off the board, all it takes is a vote. So if they are not willing to hold these meetings in the way that they are supposed to, or to even respond to you, go out and gather the votes. And that's something that It's one of the few things that we do help individuals with. Most of the time, we only represent community associations, but that's one of the few things that we will help individuals with is when there is a problem and they need to recall the board to get all these people that are refusing to comply with their obligations off the board.
This is kind of an unusual. We're going to do this. The last one that came in, one says it's KBR. That's K Bender Rimbaum. Do you have sample letters that people can use to send to the legislator?
There is one, but I don't believe we have it on on our website. But I know that the webinar that Jeff Rembaum and I did with Castle Management, Castle put that sample letter on their website. So if you go to Castle Management, Castle Group's website, I know that it's on there under their resources. I don't believe we have it up on our website.
Well, she's right.
At kbrlegal.com and check us out. But I don't think you'll find that form letter there that we're using to ask everyone to reach out to their legislators. But I appreciate the fact that someone already cared enough to at least endeavor to go do that.
Yeah, because I mean, she's right, because a lot of elder people aren't really good at putting a letter together. So yeah, I totally understand that.
Castle's got a very nice copy and paste situation that you're welcome to use.
Very good. Here's Aaron in Sanford. A lot of people from Sanford today. Is it considered a quorum if you're doing it by email? Our HOA is doing this via email, approving architecture forms, approving vendors and amounts, not done at the station board meeting, statutory board meeting.
So the answer is no. The statute is extremely clear, both in condos and HOAs and co-ops. The board can communicate via email, but you cannot vote via email. So reaching a quorum only matters for purposes of whether you are holding a board meeting or not. You cannot make a board decision via email. What you can do is have a written resolution that memorializes that there was a unanimous decision made. Now, there is something called ratifying the decision that was made via email, but that shouldn't be your common practice for everything that the association does. The board should be holding meetings to make the vast majority of decisions. And when I say vast majority, I mean about 90 to 95% of decisions. It's really only when you have an emergency and need a decision pretty much overnight, because keep in mind, when we say a board meeting, you only need to provide 48 hours notice for 90% of the things that you might vote on at that board meeting. So to say we didn't have the time, it's very rare that an emergency comes up unless we're in the middle of a storm or something like that, where you really need to make a decision today. So you really should be holding those board meetings, but the short answer is no, you cannot reach a quorum and you cannot have a vote of the board via email.
Are you seeing that these board members are keeping up their websites?
Some yes, some no. I mean, candidly, most of the websites that I see, either one board decided to hire someone and the only thing that's been updated is the official records are being uploaded as they come in. The ones that I see being updated somewhat regularly are generally the ones that are operated by the management companies themselves. So you hire the management company, part of the service under the contract is that they provide the association website. Basically, they have their portal and it's very easy for them to set up the association's website and a login credential for every member of the community, et cetera. So updates are rare. There are, by the way, speaking of updates, there is a bill that would require a smaller condo now to have a website. So frankly, my opinion is every community association should have at least a website with their governing documents, the name and location of the community, who to contact when you have an issue, and then behind login credentials, all of the other official records. Because in most instances, if you keep that organized, all you got to do is say, here's our official records behind these login credentials. When someone sends in a request, this isn't really allowed in a condo yet, but we're working on it. You just say, go into the portal and you can see all the records. Most of the time, that'll suffice in an HOA.
Well, for the last almost 50 minutes now, we've been talking with attorney Alan, and Alan is one of the finest HOA Condo Association attorneys. If you're in the Orlando area, set up some time to meet with him. Alan, give everybody the phone numbers.
Sure.
To reach your office.
Yeah, the one that's going to reach our front desk in Pompano, and they'll divert it to whoever's appropriate, is 954-928-0680. That's going to be the easiest number to reach anyone in our office. And then my email address is as@kbrlegal.com. Again, I'll thank Jeff Rembaum for making that happen instead of A. Schwartzide. And the bottom line is email is the easiest way to reach me. If you want that tailored content on a daily basis, feel free to follow me on LinkedIn as well. That's my primary social media platform.
And he also fixes typewriters at night too. So
yeah, but I do leather work.
Alan, I got to tell you, with doctors, you hear about great bedside manner. I don't know what it is for lawyers, but I think you really should have been a law professor. You are so good at explaining everything. We love having you. You'll be back with us again next month with more. Alan, Happy New Year again, and we'll see you next month.
All right, Steve, and everyone who was on today, thank you so much. Have a great one.
Thank you so much. That was attorney Alan Whiteside. Schwartzide. For some reason I want to call him Whiteside, but it's Alan Schwartzide. He's been with us for a long time. Everybody, thank you so much for tuning in today. I'm so sorry about the phone calls we didn't get to, but we were inundated today. This has been a busy, busy day. Thank you so much. God bless, and we'll see you again next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.